with this approach as such, but I want you to know that it's a very simplified approach. And when we speak about comparative law, and especially having in mind the content of today's lecture, where I will share a few rules on what you can do and anyone can do to become better at comparative law, then we should not stick to this simplified model of saying this is either civil law or common law. So I copied to you the screenshot from something you can actually find on Wikipedia. And it's a very detailed overview of systems around the world. And I hope that this is not overwhelming, but it can be explained very simply. What is blue here, even if it's light blue, that's still mainly civil law world. What is orange or pink or even purple, it depends on how you see those colors, that is the common law world. And then you see in Northern Africa, in Saudi Arabia, and also all the way to Afghanistan, Iran, you see green part. This is Islamic law. On the left bottom, you can see that according to this model, there are 5 main types of systems. It's civil law, common law, Muslim law or Islamic law, customary law, and Jewish law. But of course, and this is very important, there are mixtures. And when you look at Quebec, for instance, up here in the north of Canada, or in the north of North America, and Louisiana in the south, it has this purple color because, as we discussed last week, there are some elements which are civil law. When we look at Indonesia, the reason it comes up with this this color here is when you look at the explanation at the bottom of the page, you can see this color means Muslim law, customary law, and civil law. So a mixture of those 3 different countries. Now, what this model does not tell you is how much of it is civil law, how much of it is Muslim law, and how much of it is customary law. But what's important is for you to keep in mind that there is so much of each element that it deserves a color of its own. So if, I don't want to give any specific numbers here because it's impossible to say, but if Indonesia were only 1% customary law, then the color would be different, because then it would only be civil law and Muslim law. And that's the color you find, that is this color here, Saudi Arabia. And if I'm not mistaken, this is that's Afghanistan here, the small part on top of Pakistan. So you don't have to, do anything with this, but once you get my slides, and I'll be sending them through to the university today, then it would be great if you just have a look at this for a moment when you have some time, and try to see, because I think it's going to be quite interesting to see what types of systems exist and how different things are in some parts of the world. Okay, any questions on what I mentioned so far on this model? No. Okay, before I go on, as was the case on Friday last week and also on Monday last week. If you ever have any questions, please feel free to simply raise your hand. And don't think there are, as the saying goes, stupid questions. There are only stupid answers. So you cannot say anything stupid. If anyone, then it's me who says something stupid. So don't worry about that. Okay, with that, I start with a story today called The Blind Man and an Elephant. If you know this story, could you please raise your hand on, and you don't have to tell what it is, don't worry. I'm just curious if anyone knows the story. Could you raise your hand on Zoom, please? I'll wait for a few seconds. But it seems that the story is new to you, and that's good, because then it's more fun. So you can see on the picture here that there is an elephant and there are several men who touch the elephant, right? And these men are blind. So the first person touches the trunk of the elephant and says, this being, because he doesn't know it's an elephant, right, is like a thick snake. And that's the second person, and he touches the ears and says, oh, it's like a fan, sort of a fan, like when you use palm leaves and you use it as a fan. The third man touches the leg and says, oh, wow, that's like a tree trunk, really big and straight. The fourth man says, oh, this is like a wall, because he touches the side and it's just, a huge space. The fifth person touches the tail at the back of the elephant and says, this is like a rope. The sixth person says, this is like a spear, because he touches the tusks, the teeth of the elephant that come out of the mouth. So who is right? They all say something different. And I think you will agree with me when I say everyone is right to some extent, but at the same time, everyone is wrong, because they only see a small part. And in their way, they're right, because someone who touches the tusks, will say this is like a spear. It's maybe even cold and sharp at the edges. But of course, you cannot say an elephant is like a spear. It's also nonsense when you say an elephant is like a thick snake, right? So in a way, everyone is right, but then still everyone is wrong. And why am I telling this story? Well, it's not that today we don't do law and today we do, I don't know, storytelling 101. So when you have kids, you can share fun stories with them. That's not the reason. I want you to never forget. It's a quote I found from someone who said, we have to remember that what we observe is not nature in itself, but nature exposed to our method of questioning. What's interesting here is, this is by a German called Werner Heisenberg. That's not the interesting part. The interesting part is that that was a theoretical physicist. So why on earth am I mentioning that when I speak about law here and comparative law? Well, we must always keep in mind that how we compare something will have an impact on our observations, on our outcome later on. And this is really what I want you to remember, because I think if you keep in mind the story of the elephant and the blind man, and sorry, the story is about men, there are no women. This is not to discriminate anyone. It's just a story. I just took it here. But if you remember this story, I think you will get the main message of my lecture today, which is, don't be very narrow-minded in your approach when you do comparative law, when you investigate something. Try to be very open and try to get a full understanding of what's happening. Because when you do that, you will have much, much better outcomes. And that brings me to my, sorry, and I should add, because if you do comparative law, like the blind man do when they try to understand what animal the elephant is, then you only see a small portion of what's actually out there, and you will not fully understand. So maybe what you find is correct, like for the blind man, right? Each of them was correct in his own way. But overall, when we take a broad perspective, each of them was wrong. And if you do comparative law, like the blind man did when they observed the elephant, then you will end up like them. At best, you find something that's right, but most of it will be wrong. So what should we keep in mind? Something that's really important here is this rule: don't merely look at the words on the page. I have before me, and it's maybe something I should mention later on as type of comparative law work that I'm also doing at the moment. I have before me, cannot be seen well, but it doesn't matter, about 50 pages of EU regulations on sanctions against Russia. And I'm doing it because I'm advising a client here in Malaysia, because as much as you may be surprised, just because those are EU sanctions does not mean that anyone who is outside the EU is not affected. So I could simply look at the words on the page and then advise my client. And I think on average, it would be okay. It wouldn't be wrong. But if I keep this principle in mind, law sits within a culture, and I try to understand why the EU sanctions were put in place, and then advise my client, I think you will agree with me that on average, I should be able to give much better advice, because I know exactly, I have the background in the back of my head, right? And I know why these EU sanctions were made. And it's not just an exercise where I only look at the words on the page. So understanding the background, this is extremely important. What's also very important, and if you read the article I asked to be read, then you will know this. What's very important for someone who engages in comparative law is to excavate the underlying structure of the law. Now, you should explore whatever influence there is. And very often there are important influences. I'll get to that in detail. Something that's often mentioned, including in the article I asked to read, is religion, history, geography, morals, custom, philosophy, ideology. It's really a well-rounded approach we have to take, because we are dealing with foreign law, right? It's at least 2 foreign laws, and we cannot understand foreign law unless we understand fully at how the law operates within a culture. So these are just some basic principles I sketched down here for you. We will approach them one by one in the course of my lecture. But I think when you look at this page now and you have in mind the story of the elephant, then you will much better understand where I was coming from. if we only look at a small portion of the laws of a country or of a law, and we don't appreciate how this law fits into the context overall, when we don't appreciate why this law was enacted, when we don't appreciate what specific purpose the law serves. For instance, some laws may protect consumers. Some laws are there to make sure that there is more competition. Those are all, reasons we don't necessarily find in the law itself. But when we know the background, then we can understand them much, much better. And this is, to go back to the blind man one more time, this is like the blind man touching the elephant. And instead of asking, is there anything else to this? They just touched one part of the body. And therefore, they came up with this conclusion. When you do comparative law, you should ask questions, and not just ask questions, but also study yourself to fully appreciate the elephant, so to say, the foreign law. So if we stick with the comparison and the blind man, maybe I could say, ideally, the blind man would not have just been, standing in one place, touching that part, but would have gone all around the elephant. Start with the trunk, go to the ears, go to the legs, go to the side, touch the tail, come back all the way and touch the tusks. Had the man done that, they would not have said, this is like a thick snake. They would have said, oh, it's like trunks and like a wall and like a tail and like a spear and like fans. And also there is a part which is like a thick snake. But again, that's completely different from just saying this is like a thick snake. So having those principles in mind and having in mind the homework, so to say, I gave to you, I'm starting with my first question. And this should not be new to you because I trust you saw the question before. And it said, comparative law should also focus more intently on non-Western legal orders. And before I continue, maybe why is that a question? Why did I choose this question? Well, I was having in mind the story of the elephant when I prepared the question. And you saw the map I had here at the beginning. I'm going back now, even though it takes a while. This is full of colors, right? If we stick to traditional Western legal orders, if I want to put it so, we say there's either civil law or common law. But when you look at the color codes down here, there are 11 different colors. So I want you to appreciate from this already that there is so much more. And this is also why I say we should focus more intently on non-Western legal orders. And I was asking you, and I'm now curious to hear one example from Indonesia, which foreign lawyers could easily forget to consider. So this is a question I understand you received ahead of this class, and I hope you prepared. So who dares go first? Yes, Baron, thank you.
Thank you, Mr. Sippel. So what I think that foreign lawyers could easily forget to consider is Pancasila, which is the basic ideology of Indonesia. So it is defined in the Indonesian constitution as the 5 abstract principles. So if they are to compare 2 different laws or maybe more, the lawyers should also consider and also maybe get into more details on the principles of how the law is constructed. For example, the Pancasila itself, because most of the time when I study in FH4 as a law student, the lecturers also link it with Pancasila and the Indonesian Constitution as the judicial basis of basically every law exist in Indonesia. So that's my answer. Thank you.
Great, thank you so much, Farron. So if I understood you correctly, you are saying every foreign lawyer should know about those 5 principles of the Indonesian Constitution, because if I, again, correct me please if I misunderstood, in principle, every single law must follow those principles, or at least maybe we can put it differently. A law that is in breach of those principles, or one of them, would arguably be unconstitutional. Yeah, okay, I can see you nod. Thank you. Great. Who else? And keep in mind, this is still a very easy question. If you don't answer now, I'll pick you later on for the harder ones. Keanu.
Okay, thank you for the opportunity. I mean, continuing what Farron said, what the foreign lawyer should, the foreign lawyers probably forget, and they should know that there is also a hierarchy of judicial rules in Indonesia, where it starts from the Constitution of the Republic of Indonesia in 1945, the decree of the People Consultative Assembly, or in Indonesia we call it Majelis Permusyawaratan Rakyat atau MPR, and then under regulation, president decree, and so on and so on. So what other foreign lawyers need to remember that even though there's a constitution that regulates thing, it has to be related to the previous that have the higher on the rules, and as the governor of the basic itself. And then the other things that I'm sorry.
Sorry, Keanu, you're breaking off. Maybe you could turn off your
Yes.
camera and then continue.
Okay, am I audible again right now?
Yeah, it's better now. Thank you.
Sorry for earlier.
No problem.
To continue, I'm sorry. To continue, lawyer also have to remember that Indonesian law is influenced by the by Dutch law when they occupy the country, and then it's also influenced by the traditional cultural law and a little bit of Islamic law, like what you said earlier. So probably there will be a different interpretation or translating on certain things. That's my answer.
Right. Definitely. I fully agree. Thank you very much, Keanu. Is there anyone else? It would be great to have one more answer. Yes, Chavid, is that how I pronounce your name?
It's like you can call it Javid, but David is also
David. Okay.
Okay. Okay. From what I know, the example of Indonesian law, there are not only foreign lawyers that could easily forget, but many lawyers, most of the times forget to consider is that in Indonesia there is the autonomy of the local. So we have a regional regulation that sometimes foreign lawyers could easily forget to consider. Not only these regional regulation, but in our undang-undang or in our constitution, it's not only the source of law in Indonesia. There are also many sources of law that are been enacted by the ministry. And these law of the ministry, not many people that are very familiar about these laws. And in many of the regulation from the Indonesian government, there are some kinds of protocol, or the how do I say it? Wait a minute. Advanced rules from this regulation. So make it more clarified. Our government doesn't make it an access in these regulations. We make more rules to clarify the regulation in Indonesia. And sometimes these regulations that are adding and are meant to clarify the old regulation are not considered by the foreign lawyers. Maybe that's my answer. Thank you.
Mm-hmm. Thank you very much, Javid. So if I understood you correctly, there are laws which empower ministers or ministries to enforce regulations or decrees, I would assume something like that, to further specify certain laws. And that's often forgotten.
Yes, correct, Mr.
Yes. Okay, great. Yes, thank you. All of these answers are right. And, you know, depending on what legal system one comes from, not knowing this, one may get very confused by only looking at the law itself. So I was specifically asking this question because I think, well, I don't think, I'm sure you are most familiar with the Indonesian legal system. And to you, all of that is normal and easy. To me, for instance, it's not. And that already makes a huge difference. So when I look at the legal text of any law of Indonesia, I will not see it with the same eyes as you do. And this brings me to my next point. How can we become better at comparative law? The problem is that we see everything as though it were filtered. Now, I took this picture here because when you look carefully at the lady's face, you can see that there is a shade of the glasses even on her face. So I chose this because I thought it represents very well this filter we have. Because if it's about the glasses, well, in theory, we can just take them off and then we should be fine. But if we have the shade that's already on our face, then that's harder to get rid of. Of course, you could say, well, then just take the glasses off and the shade is also going to be gone. But imagine that that's something that's permanently there. So we cannot truly observe because everything we see is from the perspective of a foreigner, so to say, not a true observer. By foreigner, I say that because we speak about comparative law, and keep in mind it's about foreign law, right? So this is why I chose the term foreigner. The point here is we have this shade in front of our eyes, this lens, and it filters everything we see. It filters because we see things from our own perspective. So when you, Farhan, Keanu, and Javid, when you assess a foreign law, you will usually do so with your Indonesian background. Your lens is the laws of Indonesia and your education in Indonesia and what you have learned so far. My lens is, to a great extent, Austrian law, but also other laws that I've been in touch with. The point here is everyone has this lens, and it stops us to some extent from seeing clearly. And by clearly, I mean, it stops us from really seeing the truth. So what can we do? Because here I only speak about the problem. We need to find a solution, right? What we must do is shed our bias, get rid of our bias. And the bias here is the background we have. So studying the underlying data, and I copied this from the article I sent. So don't worry too much about some terms like substrata, if that's, doesn't mean much to you. But if you just focus on what I say, if you study the underlying data that lie within a culture to better understand that culture, then in other words, you are studying the culture of that country. And it allows you to appreciate much, much better what's going on and why a law or a rule is in a certain way. So the article speaks of an immersion into the political, historical, economic, and linguistic contexts that models the legal system and in which the legal system operates. So what you should do is you should consider those underlying concepts, beliefs, and reasons that underlie the law. Now, maybe you are saying, so if I want to do comparative law, should I first study history? And should I first study politics? And should I first study economy? And since it also says the linguistic context, does it mean that I have to study the language and only then I can compare? Well, that would be too much to ask, because if that were the case, you should study just about that for 10 years, and then you would maybe be ready to compare. I think it's a bit nonsensical to assume that we should always do that first, and only then we look at the law. It can go in conjunction, and also instead of you sitting down and starting from point zero, what helps a lot when you're dealing with a foreign law is that you ask an expert. And expert here, keep in mind, it does not need to be a law professor, because the person who is asking is not wanting to know every single tiniest rule of the law. It's usually in a broader sense, at a bigger picture. So that person will ask the questions, and on average, anyone who is trained in the legal system should be answered to provide the political, historical, economic, and linguistic context. Usually that should be sufficient. So don't think that you have to, study all of that for many years before you can do anything. So you should strive for neutrality. When you have the background, then you will understand much better. And you don't say, oh, that's strange, but I think typically you would rather say, oh, that makes sense. And that's because you know the background. You should also always have skepticism. When you find something strange, maybe you're right, maybe it is unusual, be it from your own eyes, be it from the eyes of a local, be it from the eyes of anyone. But you should always be skeptical, because when you're skeptical, then you will ask questions and you will try to understand better. And that will usually lead to a better outcome, to a better understanding. And as the article said, free yourself as best as you can of cultural bias. Now, it says as best as you can, and I don't think it's impossible to ever be completely free of bias, but you should strive. It's not either you do it 100% or forget about it. It's try to approach 100%. If you do it for 90%, that's already incredibly good. But again, even if you're just at 10%, that's better than 5%. So you should strive to become better. Now, what is this cultural bias, to go back there? It is your own culture, whatever you bring, but it's also the foreign culture, what you have already learned, what you know there. If let me give you an example. If you know, for instance, that in Indonesia, conflicts should generally be avoided if possible, then whether you are Indonesian or not, that's a bias you have. And you may view things with this bias. But when you engage in comparative law, you should really start from zero, forget about those biases, and try to understand more specifically what this certain rule is about. I'm putting here the question to you, is a completely objective observation ever possible? And I don't know what your views are, and I'd be happy to hear any views on this. My view is that it's not possible. But again, as I said, even though it's just an approximation and not 100%, that does not mean that it's bad. This brings me to the second question I asked you. What could you do to reduce the influence of your own lens to make it weaker? And I'm again hoping to get answers from you. But yes, and I got Nicholas already. Thank you, Nicholas.
Thank you too, Mr. Sippel. The way I do it is, or at least to reduce the bias. The way I do it is to observe, to learn, to research and study on the foreign law first, then compare it to the law we are familiar with, rather compare it just at all. So first, I would like to study first. For example, you mentioned about the historical background, perhaps. And if we look at most of the papers, journals, and such things, we usually have the introduction, the background. So we can first study on that thing and then just compare it after we are familiar with both legal system and both areas of law.
Okay, thank you, Nicholas. Don't go yet. What I have a follow-up question. What do you do in daily life? It doesn't, it doesn't say law here. It just speaks about your lens. Is there anything you do in daily life?
I'll say, for instance, choosing the transnational business law as the areas of law I concentrated in is the way maybe to reduce the lens instead of focusing on the domestic law itself.
Okay, I see. You don't want to tell me, but that's okay. Thank you. Let me. That's fine. Thank you, Nicholas. Let me give you one example of what I meant from private life. Now, when I when I came to Indonesia for the second time, I was speaking at an event. And I'll be fully honest now, I was very surprised to see that hardly anyone was wearing a suit. Because most people were wearing a batik shirt, right? Now, there are two ways for me to approach this. And again, I'm mentioning this because it has nothing to do with the law. Keep in mind, the lens here is about our own culture or the foreign culture. So I could have approached this in two ways. I could have said or thought, oh my God, these Indonesians, they are so rude. They don't even wear a suit to an important conference. You know, that if I did that, and just for the record, I didn't do that. But had I done that, I would have seen things from my own lens, from my own culture only. Because in Austria, or I think generally in Europe, when you go to an important conference, you should wear a suit and maybe even a tie. The better approach here to reduce my own lens would have been to observe first that something is different, and then second, to ask myself, oh, is this a specific custom that applies maybe across Indonesia? Is it something that only applies to conferences? What's happening here? What's happening there? Understanding this would have, and asking questions would have helped me to reduce my lens. I can give you another example. I'm now speaking about Indonesia from the eyes of a foreigner, and I think some of this you will find very funny because you are so used to it. But I can tell you that in other parts of the world, it's not the use at all. I found it very interesting. When a lawyer says interesting, usually he means strange or wrong, but that's not the case. I really mean interesting. When I texted with Indonesians, or still when I text with Indonesians, you know, just on WhatsApp, very often my Indonesian friend will simply say, Selamat pagi, Harald, right? He will write that. And then there is nothing. And then that person waits until I respond. And then that person tells me why he has been contacting me. And to you, I don't know if you do the same thing. To you, this may be 100% the same thing you do. I can tell you that I have never seen it outside of Indonesia. Outside of Indonesia, you would write Selamat, well, you wouldn't write Selamat pagi outside of Indonesia, but you would write good morning, and then you just write the reason for the text, and that's it. You don't wait for the other person to respond in between. There's something else I found very interesting in texting, and I will admit there is one occasion where I forgot I'm having on my lens. This was one of the first time I texted in Indonesia. I was working for or with an organization in Indonesia, and the secretary of that organization was texting with me. And she wrote something like, you can send it later, yeah, you know, the YA. I'm sure you sometimes do that when you write to your friends in English. To me, I was influenced here. It's very funny, but it's a true story. I was influenced by my knowledge of Korean. My wife is Korean, and in Korean, we only speak at home, Korean at home, my wife and I. So I'm more or less fluent in Korean. And when you say "ya" in Korean, it's rather rude. I mean, maybe between my wife and me, it would be totally okay because we know each other. We've known each other for a very long time. But I just got to know the secretary, and I felt that what she's doing is really rude. And I admit that. Of course, that's because I have my own lens on, right? And I don't try to see things as they are, but I just see it from my own perspective. Of course, I was not doing comparative law when I was speaking to that secretary. It was about booking a flight. But I'm giving you an example of how we can have our own lens on and what it means. And I think since I speak specifically about some things that are typical, at least to some extent, for Indonesia, I very much hope that you understand where I'm coming from. But thank you, Nicholas, again for your example. Who else has any example what she or he does to limit the influence or reduce it at least? Come on, guys. I sent through the messages prior to the class, so, and you got them, right? Yeah.
Yeah, I told the students to see your, anyone wants to give, I believe that it should be still a simple question, right, Harald?
Yes, this is very simple. It has nothing to do with the law. I think all my questions were simple, but they get a bit harder.
I think they're kind of scared. Okay, Nicholas?
So to be honest, Mr. Sippel, I do want firstly apologize because I misunderstood your question. It's not that I don't want to share my private life. It's just I misunderstood it. But
No problem at all.
now that you've mentioned regarding the private life, I would say that the way I could do to reduce the influence of my own lens is to read at least or to watch the entertainment products from the other country. For instance,
Yes.
the Korean drama, or I think the easiest example is a movie or series from US and Hollywood, which is the center of entertainment. So that
Yes.
would be the easiest way to reduce the influence. Thank
Yes, you're raising an excellent point, Nicholas. Reducing our lens does not mean that, you know, we have to do something that's very tiring, very complicated. It can be as simple as watching a movie and, you know, maybe paying a little tiny bit more attention. And then you will say, oh, that's how they cry in Korea. Or that's how they all fall in love in Korea. And maybe even when you watch Korean drama, to stick with that example, you will pick up some words like oppa. I'm sure that's a term that many of you know from the Korean drama.
Right.
Okay, who else?
Anyone else?
I'll just pick someone now. I have, sorry, Rafli Noval Insagi. I don't know which one is your first name, but what do you do?
Roughly, are you there?
Yes, because I can see the camera.
Yeah. Do you got the question, roughly? There's no answer. Would you like to wait, or would you like to?
I'm still hoping.
Oh, yeah, me too. But I do ask him to unmute. However, there's no response.
Okay, wait, now he's taking down his microphone.
Oh.
Yes, there you go, Rafli. We're all listening now.
Where is he? Hello?
Okay. I
Roughly,
think
you there? He's already unmute his mic, so I believe that.
Yeah,
Do you like
I think-
to give some perspective?
Roughly from my own cultural lens and the way you are reacting now, my observation would be that you haven't thought about this in advance and therefore you don't know what to say.
Yes.
Okay, then it's okay. I'm not going to torture you. But make sure you do the homework after the class.
Actually,
Then the next one here is Darian.
Darian,
Darian, sorry.
are you there?
Am I audible?
Yeah, you're
Yes, you are.
Okay,
We're
just to
listening.
confirm this is about what we can do to influence our own cultural lens. Am I correct?
Not influences, defluence it, so to say.
Defluence cultural lens.
That word doesn't exist, but the opposite of having an influence.
Okay, so I would think that the best way to do so is either to interact with people of other cultural influence, so people from other cultures, or even better yet, to go to that other place so we can experience the other cultures itself.
Right, you're absolutely right. Thank you. And that's yeah, nothing to add on those points except that it would be extremely useful. When you come to, maybe some of you have the impression, I don't know what you know about Austria, but you may know in Germany, I'm now mentioning something where the south of Germany and Austria are similar. You may know the Oktoberfest in Germany, and that men wear these strange clothes, these strange leather pants. Now, if you came to Austria and you came to the mountains where I grew up, and you saw people there, you'd be maybe wondering if that's what everyone wears. But if you stay for longer than one day, you would realize that it's just for a special occasion. Because when the festival is over, everyone is back to normal clothes. But you're absolutely right, Darian, going to another country is a very good way. That's expensive, of course, but just interacting is another way to reduce the lengths. So let me ask a next question that you also have seen, and that's maybe already a bit harder, but what bias have you observed? And maybe we could reduce it to some extent, because this is so much about the law, it maybe requires you to have read a lot of papers, but when you read about Indonesia and the politics, have you seen any bias that other people have? Or maybe you have seen any bias that people have with respect to Indonesia? I can tell you one bias that I see in Europe when they speak about Indonesia. And sorry here, I'm just telling you what some people think. Or they don't think much because they don't know much, but they don't even know Indonesia sometimes, they only know Bali, which is quite unfortunate because Bali is this, mini part of Indonesia. And then on top, I think Balinese culture is quite unique and in many ways is different from Javanese culture, for instance. But that would be a bias. So what if you observed? Tesliana, you're the only one who hasn't been forced to speak today or hasn't spoken to herself.
Okay, for what I observe in foreign studies regarding Indonesian law, does it has any bias towards Indonesian is yes, you say that they only know Bali and they also didn't know the what is the traditional law of Indonesia. I mean, there's some kind of difference in Indonesian law and between Indonesian law and any country's laws, and also they always subjectively about the traditional law of Indonesia, and also because they never survey or survey in Indonesian directly. Yes, I think that's the main problem is they only saw it subjectively regarding Indonesian traditional law.
Tesliana, thank you so much. You mentioned 2 points that are really important in my view. The first one was subjective, meaning they do it from their own point of view, right? With their own background. That's exactly what we were speaking about. And shoot, what was the second point I wanted to mention? I was so excited you mentioned those and now I forgot because I was too excited. I forgot. Anyways, thank you very much. What you mentioned is very important. When we do things subjectively, then we cannot see them how they really are. We have a bias. Something I can also tell you where the EU, as I view it, as my whole, has a bias towards Indonesia or maybe East Asia as a whole. Until recently, the EU did not really take Indonesia as seriously as other countries when it comes to politics, when it comes to economics or the economy. it was, you know, for whatever reason. I think the biggest issue here goes back to what Darian said. If you are sitting in Brussels and you've never even been to Southeast Asia, and all you know about Indonesia is that Bali is part of it, then how can you take it seriously? You know, and I think what I hope I'm not shocking you when I'm telling you this. I'm telling it to you so honestly to really describe why people have a bias. I'm not saying this is good, not in any way. This is really just to explain what's happening. I think it may be the similar, if I take it the other way around, you know, many people from East Asia, they believe that Austria is like The Sound of Music, if you have ever watched this movie. And I will shock you now when I tell you that in Austria, maybe 5% of the population has ever watched this movie. It's not even famous in Austria. And I see some smiles, so it's, yeah, again, this is our own cultural lens, our own subjective lens. So, you know, nothing of this has to do with the law, but only if we manage to forget about that can we truly understand the law. And let's be honest here, at the end of the day, if we work diligently on, like we see foreign law and we try to understand it and we analyze it, if we work diligently, this is not rocket science. The much, much harder part is forgetting about our cultural lens and seeing things as they really are. So this is why I'm placing so much emphasis on this. In case you're wondering, I don't know, is this a lecture on law or is it now sociology, or has he completely lost his mind? That's the reason why I'm doing this. So my next question is, was this one. The article says, and yeah, if you haven't read it, that's maybe quite unfortunate now, but anyways, it says, can we really understand the United States Constitution without an appreciation of the influence of the Enlightenment, natural law, or Republican or English Whig theory? You don't have to fully understand what happened there. You don't need to know about the Enlightenment, natural law, the Republican theory, or the Whig theory, but maybe there is one historical fact you think foreign comparatists should understand about Indonesia before they compare Indonesian law. What one historical fact were you thinking of? Yes, Nicholas. Thank you.
Yeah, thank you, Mr. Sippel. I think one of the most important facts that must be taken into account is the fact that Indonesia was colonized by Dutch, and there happened to be a difference in the law enforced to the Westerners, the Asians, as in the Oriental, and the indigenous people of Indonesia. And such differences have been eliminated, but I can give you an example on the differences in the law imposed that still influenced by the Dutch law. For instance, the court proceedings in Indonesia, especially the civil court, because the funny thing is criminal court has the specific Indonesian law that regulates it, but in the civil court proceedings, we are still rely in the Dutch law and what's so-called HIR and RBG, and I don't know how to pronounce that, but HIR applies only in the Java and Madura Island, whilst RBG applies in outside of Java and Madura, such as in Sumatra, Borneo, and so on. And
Great.
I think that's the historical facts that need to be taken into account before comparing Indonesian.
Great, thank you so much, Nicholas. I fully agree, because if I want to compare Indonesian law and I don't know that, then I will say, oh, that's so strange, you know. They even have those Dutch terms. what on earth is going on here, you know? Of course, you could say anyone who knows a little bit about history would know that the Dutch colonized Indonesia. But yeah, there are people who don't know it. And if you try to compare without knowing that, you will constantly say, oh, that's very strange. The more you know, the more you will say, oh, that makes a lot of sense. This is what I mentioned before. Anyone else?
Anyone else?
Oh, I see one more person who I haven't called so far. Thessalonica.
Okay.
I haven't called you yet.
Yeah, I think, I don't know if it's Nico has mentioned before, but that one of the historical aspects that must be considered is that in Indonesia is a country with various diverse backgrounds, so it has its own like religious laws and customary laws which are still used today. So Indonesian law is still influenced by these various cultures. Even before making laws, the lawmakers usually will adjust the cultural conditions of the people in that area, whether the laws will be compatible with their customs and whether the law will be implemented properly.
Great. Thank you so much, Thessalonica. I think you're raising a really important point here. Desliana, just 1 second, but thank you. Keep your hand up there. I think you're raising a really important point about when there are especially indigenous people or generally cultures which influence us. And in some countries, those cultures by indigenous people or generally cultures, they are extremely strong, and that's why they influence the laws themselves. So knowing that helps tremendously. Yes, thank you. Yes, Desliana.
I want to add a little regarding Thessalonica questions is what one historical facts that the foreign compares should understand about Indonesia is regarding before the colonization, there is many empire in Indonesia, whether it is a Hindu empire or in the Muslim empire. It should be studied first by the foreign comparisons, because there's still many remains empire in Indonesia until now. For example, there is many Muslim empire that still remains now, and there is many unsaid law regarding those custom law that is I mean, there is many unsaid law that been heavily what is it? Wait a minute. Affected by those empire, I think.
Thank you very much. I think that's also an excellent point. You know, someone who doesn't know anything about history could even go as far as to say, how on earth is Islam the main religion in Indonesia? Like, why on earth? It comes from the Middle East. But of course, as you study, you will understand how it came to Indonesia. And then you would also understand why there is influence from Hinduism, as you pointed out. And you would understand why, correct me if I'm wrong, but I understand that Bali, the main religion in Bali is still Hinduism, still to this date. But if you don't study that, of course, you won't know. Great. I want to tell you one more. It just came to my mind as I was observing you know, with your comments. Something that you will not find abroad, and where you may maybe think it's strange. In Indonesia, it's very common to apologize. Before you even speak, you already apologize. And I am sure that some people, some foreigners, they will think, why do they make mistakes all the time? They apologize even before they have started, you know? Why are they so bad? Or maybe they say, why do they not have any self-confidence? But that's just another example of culture and how it can influence us. Okay, great. Thank you all for participating, even though I had to force some of you. Now, let's continue here. The second problem I see is, and not just I'm summarizing here the views of people who engage in comparative law. We only look at the words. So we do not understand what is lying behind the words of this particular act, what the background is. I already mentioned that to some extent. But let me give you an example from Austria, my home country. Because I'm quite sure you have not dealt extensively with Austria, and you shouldn't, because it's a very small country that is not very important. But I think that suits well because you don't bring any bias, because you don't know much about Austria. Now in Austria, we have the Prohibition Act of 1947. And what I should tell you before I speak about the Prohibition Act is that I think you would agree with me on that, that in Austria, generally, human rights are very important. There is the right to free speech. You can pretty much say whatever you want to say. There is the right to assembly. You know, you can form organizations, pretty much any organizations you want to. And the right of free speech also includes that you may use certain symbols or certain, you know, you may use a T-shirt that says, and I hope I'm not, what's the term I'm looking for? Making anyone angry here or even insulting anyone. I'm really just using an example. In Austria, you can wear a T-shirt that says, God is stupid. You know, it's just an example. I'm telling you this to show how important free speech is. But then what does the Prohibition Act say? You are not allowed to support any neo-Nazi organization. You are not allowed to form any neo-Nazi organization. You're not allowed to use any Nazi or neo-Nazi symbols. Now, if you're not even allowed to support an organization, then you could say clearly this is not in line with human rights, the rights to assembly. The prohibition of certain symbols, it's also clearly against free speech, right? And what's probably gonna even shock you more is the courts say, this is now standing jurisdiction in Austria, jurisprudence, sorry, any reasoning or argumentation concerning the Nazi genocide and the Nazi crimes against humanity is not admissible in evidence. So it's a given fact, you cannot argue about it. So I'm asking the question to you, does Austria not respect human rights? What's going on here? Because even the courts say you cannot say, no, I don't believe what is written in the history books. I think it was different. You're not allowed to say that, and it's not admissible as evidence before courts. Now, if you only look at the law, you may be coming to the conclusion that Austria doesn't respect human rights. Because I should tell you that the Prohibition Act is part of the Constitution. So it's a super important law, and there's nothing you can do about it. But then when you look at the title, it says 1947. If you know a little bit about history, you will know that in 1945, the Second World War ended. And if you know a little bit more about history, you may be knowing that Adolf Hitler was Austrian, not German. Yeah, I can see Desliana being surprised. Everyone thinks he is Austrian, and we are happy. Sorry, everyone thinks he's German, and Austrians are happy if people think that, because it makes us look better and the Germans worse. Because, you know, Germany is much bigger than Austria, and we share the language, and culture-wise, many things are different. So whenever we can be better than Germany, so to say, it makes us happy. But when you know these facts, then you will easily come to the conclusion that this law was made right after the Second World War. And I can tell you that Germany has a law that's quite similar in some ways, because the people who were in power in Austria back then thought that all of this is so important. In other words, history must never repeat itself. So there must be really strict laws, even if, you know, you could say, if you just read them like this, you could say there is no free speech in Austria. And you could say there is no right to assembly in Austria. But you would never understand all of this unless you know about the historical background. So this is really my point here, which opens your eyes, I hope. And it's a very good example where only looking at the wording of the law will, yes, it will make you understand what you cannot do in Austria in a limited sense, but you will definitely not understand that law, because to understand that law, you have to know all about the history, and above all that the people who came into power after the Second World War in Austria and also in Germany, they said history must never repeat itself, and it must never happen again that there is a second Adolf Hitler. And this is why we have so strong laws against this. Because what's surprising here, when you look at history overall, you will see that some communist regimes, like in the former Soviet Union, like in China, like in Cambodia, to some extent, if I wanted to compare, and I'm not doing this, but just for the sake of the argument, you could say under those regimes, even more people died than under the Nazi rule in Europe. So this should also be forbidden. I mean, you could in theory make that argument, right? If you say this was even worse. But the difference is that this did not happen in Austria. It happened outside of Austria. So in Austria, in my country, it's much more important to say this must not happen again because it already happened here. And this is why it's forbidden. So it's maybe a bit strange to you, but it is allowed in Austria to say communism is great. It is allowed to say to use communistic symbols and so on and so forth, while you're not allowed to use neo-Nazi symbols. And please don't misunderstand me. I'm definitely not saying that this is bad. I'm not saying this is good either. I'm just explaining here. I'm objectively observing and explaining to you. Well, and to be precise, I think it is good that Austria has those strict laws because it's part of taking responsibility for basically causing a lot of problems in many parts of Europe, at least, and outside of Europe even. So I think when a country takes responsibility by being so strict against anything that has to do with the Nazi regime, I think you're actually showing that you take that responsibility. So what can we do to be better? we should understand how the legal rule fits within the broader framework of the legal system. Here, the broader framework is, oh my God, this is even constitutional law. But then the broader framework is, or the understanding of the broader framework is, yes, but it was made just after Second World War, when millions of people had died, when in Austria alone, several, I don't know the exact statistics, but at least tens of thousands of people were dying in concentration camps. So I'm not even speaking about the soldiers here. Then you understand the background of the rule. Then you understand why the law was enacted and what the intention is. And we can also understand the intention of specific rules. So I'm here narrowing it down because my example was about a law as such, and to some extent how it fits within the broader framework of the legal system. It's part of constitutional law, but very often you can also understand that about a specific legal rule. For instance, if I'm not mistaken, there are two provinces, or at least one province in Indonesia where Sharia law applies, if I'm not mistaken. So if you only study, imagine someone from outside of Indonesia only studies the laws of this province. And if Sharia law applies, you know, some punishments are very, very severe. If I'm not mistaken, when you are a thief and you get caught, your hand may be chopped off. Now, if you only only study this particular law of that province, you may say, oh, Indonesia, they do it like in the 1600s, you know. It's a country that's very cruel. It's a country where just for stealing, you may risk dying because, you know, when the hand gets chopped off and it doesn't get treated, maybe you get an infection and you die. But it would be completely wrong, of course, as you know. I don't need to explain to you. You know much better than I do, but it's just one example once again. And you would understand how this rule fits into the system overall. Yes, in some parts of Indonesia, Sharia law applies, but it's very few parts. And well, in those provinces, Islam plays a very important role, and this is why it applies. Full stop. We can like it or not like it, but that's not our job here. Our job as comparatists is just to try to understand and you know, get a grasp of why things are as they are. This brings me to a next question here, which I hope helps in understanding. And there is a difference between law in the books and law in action. And by law in the books, what's meant here is this is what the law says, but this is how it's really done. And I'm wondering if any of you thought about this and has any comment here. If I give you my examples, you will say, oh, of course, I should have known that, but let's see. Did anyone make any thoughts? Yes. Thessalonica.
I think the Indonesian marriage law, it seems so inconsistent because in Indonesia the law prohibits the interfaith marriages, but many people going abroad to get married and then come back to Indonesia and register it to the administrator, and the marriage becomes legal. So I think there's inconsistency in the law itself.
Okay. Great. That's a wonderful example. Thank you. Nicholas.
I have to agree with Thessalonica because there is inconsistency even in the law in the books, because the inconsistency arises from the private international law regulations versus the marriage regulations. But I could give an example related to the littering prohibition. because every province, because I think Jafet already mentioned that every province in Indonesia can impose or draft bills and regulations. So
Right.
to my knowledge, almost every province in Indonesia have the prohibition of littering. But until this day, if I've lived in 3 provinces, if I'm, yeah, at least 3 provinces, North Sumatra, Jakarta, and now in the West Java. I've never seen anyone get imposed after they littering through trashes anywhere. So I think that's the differences between law in the books and law in action.
Right. Great. Thank you to both of you. Those are great examples. All the while, with due respect, I think you are thinking way too complicated. Let me give you an example. When you are walking on the street and you want to cross the road, you can just do it, or you walk to a place where there is the traffic lights. Now, the law in the book says you can only cross when it's a green light. But let's be honest, we don't always do that. Now, this is really a small example, but I want to highlight it to tell you that so often it is really just ahead of us, and we don't see it, right? I put this question here because comparatists should also look at how laws are enforced in practice and whether there is any difference. Sometimes the laws allow the enforcement agencies to apply their own judgment. Sometimes the enforcement agencies, do it whatever they feel like. I'm not going to get started on police. I think it's a big problem in many countries of the world. And I'm not even speaking about bribes here, just generally. Maybe in Austria, if I'm speeding, I will definitely get a ticket. If my wife is speeding, she will likely not get a ticket because she's a woman. And on average, Austrian policemen are going to treat women, much more nicely. Now, is that what the law in the book says? Of course not. But it's, I want you just really to realize and understand that sometimes those are very small points, and someone who comes to compare and comes to Austria and says, oh, they have very clear rules on speeding and it's very strict, would in principle, that person would not really reach the right conclusion, because I can tell you again, what I have to do as a man in Austria is I have to explain a lot, and maybe I have to tell the policeman that I'm a lawyer. That also helps. And it's unfair to do that because I should just pay the ticket when I'm speeding, but I don't want to pay it. I'm sure you understand. But this is one example. If I only look at the text itself and I don't understand how the law is applied in practice, I cannot really understand it. So this is why I highlighted this example. But the examples both of you mentioned, Thessalonica and Nicholas, they were great. The only thing I said is you don't even have to go that far, and think about something that doesn't really affect you. Even in daily life, there are many things that affect you. One reason or one point where law and practice plays a big role for lawyers is, and we can say it's comparative law. It's very important for foreign investors to establish a company abroad, because that's often how they do their investment. So there are those guides called how to do business in, something like that. And sometimes they compare countries. They say the ease of doing business is better in Indonesia than it is in the Philippines, something like that. Now, what they do to arrive at their conclusions is, among others, they observe the law. But if you have ever worked for a law firm in Indonesia and dealt with foreign investors who wanted to establish a company, you will know that the law says one thing, the practice is another thing. And it can be quite deceiving. But again, we need to look beyond what we see in the written law itself. Problem 3 that I see is we ignore legal culture. So here I'm not speaking about culture, I'm speaking about legal culture. So what is that? It's an important part of law, and unless we understand it, we don't understand the law itself. What can we do? And I'm speeding a little bit because we only have a few minutes left. Sorry for that. We should understand by what legal culture is run, how it functions, and how effective the cultures are, and how they influence and form the culture. For instance, the article says we must understand the invisible dimensions of law. That is, the underlying forces that operate within a society to help form and influence law and give it substance. What do I mean by that? For instance, I'm quite sure in Indonesia, as in any other country of the world, there are some strong groups that may have a power and influence on the lawmakers. They do lobbying, as we say. We may be knowing this best from the US because every now and then there is an inquiry by the Senate or someone else, because they realize that some companies use millions and millions, even hundreds of millions, to lobby with politicians to make sure that they get the law in a certain way that they would like to get it. This is one example of an underlying force. Because if we understand that, say, the chambers of commerce played a very important role in the shaping of a law, then we would understand why it is maybe more business friendly than it is consumer friendly. If, however, consumer organizations had a very big say, and maybe if elections were not so far away, and the political leaders understood that it's important for them to show that they care about the people, then maybe a law is more consumer friendly. This is really just another example. But here we have history, religion, ethics, geography. It can be any underlying force, but very often legal culture is heavily influenced here. I'll skip my question here because I've already asked each of you, and I'm running out a bit of time so that I can finish that and speak about my last rule. And this is really something that I want you to be your takeaway from this lecture, because that's the most important part, even though it has little to do with the law as such. Now, every time we engage in comparative practice, we should ask ourselves at the end, what have we learned? So we read the law of this country, of that country, of that country, we compare it, we fully try to understand, and we should then take a step back and ask ourselves, what have we learned? It's only when we do that through structured learning, and that includes, taking a step back and asking ourselves, that we can improve overall. And by improving here, I mean above all that we get rid of this lens, we have that blurs our views. You should ask yourself, what is the significance of my findings? Do I now understand the legal system or this particular rule better? And if so, why is it? Very often the answer to the question, do I understand it better? It's easy, you say, of course. But if you go back and say, why do I understand it better? Then maybe you will realize, oh, it's because I understand about history much better. Oh, it's because now I understand much better how, maybe now you will say you now understand better how Austrians think. you know about the Prohibition Act, right? That's probably the only law in Austria you know about, but you know about it. So if you ask yourself, why is it? What step did I take that allowed me to improve my understanding? Then you can apply that in the future. So what has your study taught you overall? In brief, what have I learned? This is really what I ask you to do at the end of your own studies in comparative law, because it will increase your learning by a factor of 5 or maybe even 10. If you just sit there and then say, yeah, I improved and yeah, I like it, you know, you don't really learn that much. But if you really go back and ask yourself that question and think hard about it, your learning is much, much greater. With that, my question to you is, what have you learned? And I ask you, I'm not sure we have enough time today, but I ask you to think of one takeaway from this lecture and why this takeaway is important for you. And I hope there was at least one thing that was important. If not, I didn't do a good job, but I hope there was at least one thing. And yeah, with that, I'm at the end of my lecture. And I thank you all for your contributions, and the Transnational Business Law Department, of course, for having me. Thank you. Terima kasih.
Thank you very much, Harald. Anyone would you like to answer the last question of this lecture? What have you learned from the comparative law? Anyone would like to give their own perspective? No, Darian?
I suppose if there's any takeaway from this lecture is that the importance of culture on comparative law, which previously I wasn't aware of that it was a thing, but now I'm aware of. So that would be my main takeaway from this lecture.
Great.
Okay.
That's
Thank
great.
you.
Thank you, Darian.
Yeah, Farron?
In my opinion, my own takeaway of this lecture is I realized that comparing laws are not that simple as when we do it only for maybe tasks, it will be just all about the verbatims, but we have to pay attention to a lot of details. For example, how we can shed our biases, and then how we can analyze the laws better from maybe the background of the law itself, how it was established, how it came from, and how it has connections and links to other laws. It is very important. Then after we do all of that, the details that we are paying attention to, maybe we can have better outcomes at comparing two or more different laws. And at the end of the day, we can give explanations on how it is different and how it is the same in a better way, or in a more detailed, and it has more background to it, so people can understand better what we're trying to give when we talk about it. Thank you.
Thank you, Farron. Next, Javid.
Okay, it's actually hard to just give only one takeaway from these lectures, because I have taken so much from your lectures, Mr. Harald. And if I can conclude on what I get and give only one takeaway, I guess that would be, on doing comparative law, you're not comparing two different laws. What I get is, when you're doing comparative law, you're comparing these laws that regulates the living in the states and the law that regulates the living in the other place. You don't you don't make a comparative studies only on the laws, but you make a comparative studies on how does this laws become a regulation, how does this perspective become a law, and how does the law regulate the people in the states or in the place. Maybe that's the takeaway from me. Thank you, Sir Harold.
Thank you.
Thank you, Japhet. Next, Nicholas.
I think if there's only one takeaway, I mean, of course, I agree with Jafet that I can take many things away, but if there's only one takeaway, I'll say that you really changed my perspective on what comparative law is. That comparative law is systematical study on two or more legal systems on a comparative basis, and that's enlightened me because I always thought that the conflict of law, the private international law, is a comparison, but apparently it's not. So I think that's a takeaway, and not to mention the points that have already brought up by my other fellows, Bang Darian, Farhan, and Jafid, that we always have to consider the background, the historical approach, the cultural approach of how the law was drafted and put into place. I think that's all from me. Thank you, Mr.
Thank you.
Thank you, Nicholas. So I believe many of the students already got acknowledgement from this lecture. Harald, thank you so much for your time, and thank you so much for giving us many insights that it's quite impressive, of course. I believe that will be the end of this section, our third lecture with Harald Sippel. Thank you so much for giving your time and opportunity, and of course your insight towards this lecture. I think that it will be the end of this semester lecture with Harald. We would love to have you in the next semester, I believe. Thank you so much, Harald, for your time. Thank you, students, for having this class. Pak Mursal, would you like to give a closing statement? Pak Mursal, are you there? This.
Budita, enough. Sorry, I just had another meeting. Sorry.
Oh, okay. Okay. Thank you so much, everyone, for having this lecture. Therefore, I believe that we came to this end of the section. Thank you very much. Selamat siang. Have a good day, everyone.
Thank you, Budita, and thank you, Mr. Sippel, for the lectures.
Mr. Harold.
Thank you, Mr.
Thank you.
Terima kasih. Selamat siang.
Terima kasih. Selamat siang.